Okay. Good evening, good afternoon, ladies and gentlemen. Let us resume our session. I would like to believe that most of us are here, so we can just carry on with our session. Before I introduce a new topic, I wanted to run through a quick recap of what we did yesterday. We started off with our criminal court practice by going to the introduction. We discussed the general sources, the Constitution being the main source that we rely upon when we're dealing with criminal court matters. The different pieces of legislation, well, what I had discussed obviously is not all the laws that are applicable when dealing with criminal cases, but I just highlighted a few that I thought were going to be good examples to show how this legislation finds application in practice. We discussed how some of these legislations come about as a result of the events which happen in the communities whenever there's a particular type of offense that is being committed a lot. That's when there would be outcries from members of the communities and lobby groups, and that would ultimately end up with the legislature being called upon to legislate those kind of offenses. And these are just a few that I discussed, but there's many, many examples. So we discussed also the common law, that it's still a very relevant and useful source that we consult when we are dealing with presentation of evidence. And we follow the principles of law of evidence being the ones that would give us guidance in determining which type of evidence would be admissible and what kind of evidence would not be admissible before the court. And we also touched briefly on textbooks, articles, journals. And I did say that these are not all the sources, that there could be many others. And I just encouraged everyone to take it upon themselves to go through your manuals and see if you can pick up any more you could refer to. Someone's mic is on. Can you please mute yourself, please? Because we're getting a background noises. I can't see now for some reason. My network, I think, is not so good also. I can't see. Please mute yourself if you're not speaking to us. And then we touched on the participants in a criminal case. We talked about the police/other law enforcement agencies, discussed at length about the term of a peace officer. And we had quite a bit of a discussion there. And I think the position is clear regarding those peace officers that were initially the ones that were the South African police services and the military, but we are well aware that this term of a peace officer can be extended to cover the other law enforcement agencies. So the only way to know if really they have that authority is, of course, that they will have a written authority which extends these powers to them. We also discussed about the prosecuting authorities, their powers as the dominus litis in terms of determining the cases that they would prosecute and the ones that they wouldn't prosecute. We discussed also about the risks of cases that are brought to court upon arrest and later being investigated, which leads to a lot of lawsuits that come up as a result of unlawful arrest and unlawful detentions. And that we discussed about the fact that it is upon yourself as the defense lawyers to ensure that you will make your representations to the state at the earliest available opportunity so that you have a record to show that you have actually engaged with the state to try and get them to not proceed with the matter, but for one reason or another, they have decided to maliciously continue with the prosecution where they ought to have not done so. We discussed the state witnesses, their roles, and we discussed how to ensure that if you find yourself having to consult with them, that it should always be done in the presence of the state prosecutors, and that you cover yourself, that there wouldn't be any later reports that you had in any way them not to testify or to proceed with the cases. Now, there are situations where you may be in court, you may not know that this is a state witness. They just come to you because they see you wearing a court gown, and because sometimes the people, when they come to court, they really don't know who is who. Although you, as a role player in the court, you will start to know that, to be able to tell who is the defense lawyer, who is the state prosecutor, because of the way the robing is different, and who is the presiding officer. But the members of the public, sometimes they are not really clued up about those differentiations. So they may come to you and start discussing about the case. And when you are already in the middle of the discussion, you may find out that this is actually a state witness. So what do you do there? Because you didn't approach them, they approached you. You had no idea who they are. Immediately, if you find out that they are going and talking about, the case, and they turn out to be actually a state witness, then you just walk with them towards the prosecutor and you tell the prosecutor, I was approached by this lady or this gentleman, and I've just discovered as we were talking that they're actually a state witness. They were informing me about some matters that concern the case. So you hand them over to the prosecutor. That way you can't be blamed for what had been disclosed to you, because you didn't call for that information. Defense witnesses, we discussed that you consult with them separately, reduce their consultation statements down to writing, to make sure that they are signed and dated, and do not consult with your witnesses together in one room to avoid influencing your defense witnesses on how they should be testifying later in the court. And you get instructions from the accused as the legal representative. So you have to always know your position in terms of you being the legal expert, no matter the title or whatever status that your client may have. You still remain to be the one who should know the law, and you should make it clear to the client that they can advise, or rather tell you whatever they want to tell you in terms of the instructions they want to give you, but you still need to check up on it, through consulting of the relevant law that would be applicable. And yes, we discussed also about the issues of inexperience and negligence, how you would ensure that you are not exposing yourself to be quoted in those many, many case laws that are already out there. Conflict of interest, we discussed also how you as the lawyer should always make sure that you act in the best interest of your client. You always have to make sure that your relations with your client are not hampered in any way by any misunderstandings. Whenever issues of disagreement come up, You need to establish it clearly what is the issues of concern. And once you have ironed out that really you have hit a wall between you and your client, then you may find yourself being duty bound to withdraw from the matter because you will not be able to effectively execute your mandate. We discussed also the different versions that the clients can give you, also when they implicate each other. Records, transcribed records, the challenges that we face in court, we talked about that as well. And I think we ended up here when we entered now the pre-trial stage. We discussed about some ethical rules concerning your approach as a lawyer and how you would conduct yourself with regards to taking on work, and how you should always give confidence to your client, avoid double booking, and to fully explain to the client the cost implications, which tends to be one of the things that seems to be something that is not very clearly explained to the client. So from the outset, you make sure that the client will know your billing structure and you keep them up to date. If the matter is continuing beyond what you had initially agreed upon, you ensure that you cover all those eventualities that may lead to you needing to charge more than what you had informed the client would be your fees from the outset. Then we discussed about the rights of the accused persons, and we said there's presumption that the accused is innocent until proven guilty. And also this is backed up by the provisions of Section 35 of the Constitution, when we discussed when these rights would kick in, and we went through several of these rights, being the right to remain silent, the right for the accused not to self-incriminate themselves, and the right to access the docket, the right to be brought before court within 48 hours, right to a speedy trial. And we eventually stopped where we said this is not an exhaustive list of rights. There are other rights that the accused have. It is upon yourself that you should make sure that you know all the rights that the accused has, because if you know, it's difficult for you to ensure that there's a enforcement of these rights if you are not fully aware of what all these rights are. So do we have any questions before I introduce a new topic, or do we move on? That was just a quick recap. Fingers going up, I suppose. No questions. So ladies and gentlemen, the next topic is establishing relationship with state officials. Now, hello? Okay. Now, when we discuss about the different state officials, the first one that we will be dealing with is the investigating officer or the station commander. The investigating officer is very important in a criminal case, and this is because once a report is made at the police station of any commission of a crime, when a case is opened, it's captured into the police systems. The first thing that happens to that case, once they've determined that it is a case that, according to the police from the outset, is what they will be able to take on, and it would be taken for further investigations, they allocate an investigating officer. The rank is not really going to be of a particular rank. There is detective units that are at the police stations. So the, what do they call it? Client services centers, which in the past used to be called the charge office. That is where the members of the public would go to make reports of cases. They would be the ones who are in the forefront of the police stations. And then that unit of the detective units would either be situated at the back of the station or somewhere in the same premises, but maybe on the side in another, building in the same premises. So these officers, you're not going to meet them when you come to report a case. You only get to know them once they are allocated as the ones who will be running the investigation of the case. So they are not arresting officers. They are the ones allocated the investigation of the case. They are the ones who will be doing different roles in terms of running with the investigation of the case. So it is very important once you are called that, there's a matter where an accused is in custody, and then the first thing to do is to establish who is the investigating officer. If you have any problems with how this investigating officer is running the case, you can then make a report to their commanding officer. Normally, they're called station commander. That is like the line manager who is responsible to oversee that these investigating officers are doing their job as they ought to. So why do we say the investigating officer is very important in a criminal case? Because they keep the docket. And I say keep, literally meaning keep. These officers, I said they have offices that they are allocated at the station. And because in most instances, they are the ones who are going out to maybe move to get information on the case, either to obtain state witnesses, statements, or they are the ones who are taking the exhibits from the stations to be taken for testing to the testing centers. So in most instances, you will not find the docket at the police station, because as they are all going up and down, doing the, they move with the dockets. Whether you agree or not, it's up to you, but that is the reason why they will tell you when you get to the police station and you ask, obviously before even a prosecutor on the station can entertain your request for bail, they have to see the docket. So in most instances, they will have to be called that please bring the docket, and. So they're the ones who are in charge of the safekeeping of the docket. They know what is happening with the investigations in terms of what is still to be obtained, if there's still outstanding investigations, and they already know what they have already gathers at that stage as evidence in the docket. So they are very important. They can say when this docket can be brought to court. Like I said, they know if there's any forensic testing, any ballistics, any DNA that is still to be done or has been done already. They will also even know the outcome, the results of the tests. They will be even able to say when those results, if they are still to be completed, when they will be available to have results. So yes, an investigating officer is a detective. They can also, now this is important, when you are looking for bail, they can also either oppose your bail application or not oppose your bail application, depending on obviously whether that is a matter that is at the police station or at court. So even at the police station, the prosecutor who decides, I mean, themselves as actually the investigating officer, they can be consulted to get a police bail, or at the police station when it's after hours, then they can be, consulted by the prosecutor who is on standby to get their attitude on bail. Now, even when the matter is in court, they are the one who will be coming to testify or make a statement that will be used to either oppose or to say what is really the case about on the side of the state. So they are very important. If the client is being kept in custody, so you discuss with them about bail, whether they oppose the bail. And if they say they oppose the bail, you can ask them the reason why do they oppose the bail application. There will be information that maybe it can happen that you have information that you are of the view that it should be informed to the investigating officer, because their reach can be longer than yours as a defense lawyer in terms of accessing certain information. If you think that will help the accused, you are, going to tell the investigating officer about that information so that they can follow it up and also now bring, a report about that information, a lead that you have given them. But if you do this, you first have to get permission from your client, whether you can disclose that information or not. And also check that it is not going to end up being information that can be incriminating to the accused. So the best interest of the client are always important. And here we say it is important that you establish a good working relationship with the investigating officer, but you don't compromise your position so that you are not going to start now being doubted whether you are working with the police against your client, or so don't let the lines be blurred by how you relate with the police. Yeah, so avoid disclosing anything that can be, prejudicial to your client, and hope that all will work out. And that is the investigating officer. The next state official is the prosecutor. We've discussed about already the power that they have. Once the docket has been opened, there's an investigating officer, it goes now to the hands of the prosecutor from the police station, who will now be on duty normally for the after hours bails, and they will then decide also there on issues of bails, and if the matter is what is beyond their powers to decide on, then they would refer the matter to court. So just one last thing on the prosecutors, ladies and gentlemen, they do have a ranking system as well, just like the police who have like constable, sergeant, captain, whatever. They do have also a ranking system. So the prosecutors that you would ordinarily find in court would be answerable to a senior. So if maybe you are making some, submissions concerning a bail in the court to the prosecutor maybe, and you don't get joy, you can take the issue up to their senior, who is either a control prosecutor or a senior prosecutor, and further deliberate on the issues that you have with them. And if you're still not happy, you can go beyond the senior prosecutor to some courts. They have a stationed chief who is, depending on the size of the court, of course, there will be a chief prosecutor on the premises, and you can also now make submissions to them. And they also report to now the DPP's office if you don't get joy at that level. So there is a ranking system. It doesn't mean if you went to this one prosecutor and they don't agree, you just take it up until you reach the NDPP. So they have a ranking system as well. And the best way to communicate some of these things, especially if you are going higher and higher, it's obviously to make sure everything is in writing so that you have a trace of all the communications that have been made between yourself and the state. The next state organ is what is known as the clerk of the court in the lower courts, and there is also a registrar. You find these ones also you find the registrars in the high court. In the criminal courts, they are only at the high court. So their role is purely an administrative one. They are the ones you would approach to pay bail after it has been set by the court. If you need to pay a fine, after sentence has been passed, you will approach the clerks of the court. They are also responsible for the safekeeping of the charge sheets and the criminal record books. They receive the requisitions form for the accused persons who are in custody. So if you have a client that has already been remanded to custody and their next court date is still in the future and you are newly on record and you've just been instructed, you are so eager because you want to prove yourself, obviously, that you are very efficient as a lawyer, you are worth every buck that the client is paying you. So if the client has already been remanded to custody without bail, you complete what is known as requisition forms. Then it's forms that are calling on the correctional services to release that, not really release, to bring that person to court, to be brought before court earlier than the date that was already previously determined by the court. So you make that request at the clerks and they will assist to communicate those kind of requests to the correctional services. And the clerks will also receive your appeals, your reviews, and your requests to have the records transcribed, because there's lots of forms that get completed there. So if you need to pay for your transcripts, you will do that also there at the clerks, and you follow up with the clerks when the transcripts are supposed to be available. Please take note, because South Africa is a country that has, is it 11 official languages? I think it's 12 now with sign language. I think if it's already been introduced, but yeah, we have a lot of languages that we use in the courts. So the standard is that in most courts, they operate with English, but there are some courts where if the presiding officer, the PP, the defense are all conversant in Afrikaans, the accused also is conversant in Afrikaans, I've seen them, proceeding in Afrikaans, but that practice is diminishing. So the most commonly used language in the courts is English. But of course, the witnesses, when they come to court, they are always going to be asked whether this is a citizen or it's a foreign national. They will be asked which language do they speak or they prefer to speak, because most people would say, I can speak English, but I am more comfortable in my home language. So because of that, there's a lot of usage of interpreters in the court. Now, why do I bring in this issue of interpreters? There is a lot of cases that are won or lost as a result of incorrect interpretation. It is good if you are able to be multilingual. It helps you because even when the witness is speaking, you are already able to follow what they are saying. And when the interpreter is relating to the court, you are able to follow that they are correctly, passing the information as it has just been said by the witness. Now, if they make a mistake and they don't say exactly what was said, you are able to interject, and you can even ask that the recordings being played back in order to address that incorrect interpretation. But if you don't know, other languages, I am telling you, you are going to miss a lot. And what I've seen is that with the interpretation, the office of the interpreters, they also have their chiefs and whatever seniors in their ranks. People who are placed in particular courts, they have those that they know they are good, and those that are just, lukewarm. Let me call them like that. So if the matter is in the lower courts, you are likely to get those who are not the best of their crop. So remember, when you're starting out, you are likely to be dealing with matters in the lower courts. So this is very important because that is where most of the incorrect interpretation happens. And for it to be brought to light, if you missed it, it comes up when the matter goes to appeal in the high courts. And the judges, they come back and they would ask that, how was this missed, how this wasn't addressed, and all that. So, if you see that there's a continual, mistakes that are being done, you rather just, don't be worried about spoiling the record, because there's that thing that they will say, you keep interrupting, you are spoiling the record. No, you are ensuring that the correct information is being, conveyed to the record. Because remember, the judges, when they are sitting with this matter, they are going to be looking at transcribed records. They are not going to have an opportunity to listen to the tapes to see whether indeed what has been typed out is what was said in court. So it helps, ladies and gentlemen, if you can take time and really just improve your language skills, even though you may not be the best at it, but yeah, to just pick up. If something is wrong, immediately address it. Immediately address it. And if it happens throughout a trial, that there are so many occasions that you've been complaining about this, wrong information that is being passed on to the presiding officer by the interpreter, it will reflect on the transcribed records that continually the defense kept on raising issue about incorrect interpretation. And that if that matter ends up in a conviction, that is also something that can sway the judges to see that maybe indeed that Kotako had made a mistake by not, properly addressing the issues of interpretation. So in practice, when it happens, you interrupt, you ask that the matter be played back, you can even ask that interpreter who is in court with you that you want their senior to come in the court so that they can also listen in to hear that this person is passing the correct information across to the presiding officer. So if they are found to be, continually making mistakes, they don't waste time. Immediately we are not there to make friends. We are there to act in the best interest of the client. That interpreter can be removed and they will get someone who is better able to do proper interpretation. So that is why I make that note and I request that you pay attention. Don't be, looking at the clouds or the ceilings in the courts, because anyway, South African courts, most of them, they are old and there's nothing fancy to look at there. Be present, pay attention, don't miss out on this important mistakes that are happening. So pay attention. Be wakker, that's what I'm saying. Because if you're sleeping, that's when you miss. Okay. The next part of our topic for discussion, we are still on the pre-trial, ladies and gentlemen. This will take us, I think, to maybe, let's see how far we get. But here I want to talk about the investigations. Do we have questions before I start this topic? I'm going to run a bit because I'm hoping we can finish a bit earlier than what we did yesterday. And I'm trying to avoid a situation of, what they call information overload. I don't want people to complain that I promise to give breaks and knock off early and it doesn't happen. Okay, so identification is the first topic under investigation that I want to discuss. Now, evidence of identity, it may be proven by direct evidence or circumstantial evidence. Circumstantial evidence is what? It's evidence of fingerprints, handwriting, shoe prints, DNA, sampling that is collected from blood, hair, semen, / body fluids. That is your best examples of what I'm talking about when I talk about circumstantial evidence. So direct evidence would then be from the testimony of a witness who comes and testifies in court, and they say, X says, I saw Y doing this or that. So direct evidence of identity is always going to be treated with caution. Why? Because it's information that comes from a human being. And as we know, we are prone to make mistakes. Even the circumstantial evidence will be treated with caution, but I just have to say, because people would think if it's direct evidence, this is an eyewitness who says, I witnessed the whole event happening in front of me, and this is what I saw, then we don't have to worry. But I say no. That is the most challenged type of evidence in court. Now, the identification can happen, like I said, with an eyewitness and also through identity parades, which are the parades which are going to be organized by the police. When they have made arrests, they will then compile or group together a group of people who are going to be put on a lineup to make up this parade, where the accused will be included, and they will have the state witnesses come and look at the people and make their observations, whether they are able to positively identify anyone who's on that lineup as the perpetrator of the offense that has been allegedly committed. So at this parade, the accused has a right to have their legal representative present. However, the legal representative who is allowed at this parade only comes there to be an observer. So you are not allowed to interfere. Whether things are going wrong or right, you just simply take a detailed notes of the going-ons that you are seeing, because maybe you may want to challenge how that parade was handled and conducted, and maybe also, which is not ideal, you may actually want to be a witness in your own case. But the idea is you pick up whatever that you would be wanting to deal with in the trial and challenge it in the court. So you just make your notes. Please take note of these cases that I'm about to discuss, and they are based on how the court applied the cautionary rule when it comes to identification of persons, where we are dealing with direct evidence. In R versus Shileke, the court held there that gross injustices are done through honest but mistaken identification. People often resemble each other. So great caution should always be applied when we are dealing with evidence of identity. There is a test that was set in the two cases that are on the slide there of Mahlape and Mutetwa. Mahlape's test is that we need to determine that the identity, it must not just be an honest identity, but it must be reliable and trustworthy. And with the state versus Mutetwa, the court in that matter gave a list of factors that a court must consider in determining whether to accept evidence of identity or not. It's a list. And this is to guard against bona fide mistakes on identity. So the factors that are to be taken into account by the court in terms of the state versus Mutetwa case are the following. The courts have to consider whether this witness who is before court that is giving this information on identity, do they have any prior knowledge or acquaintance with the accused? If so, we check what time did they make the observation? Was it daytime? Was it nighttime? If they say they know each other the witness says they know the accused before the incident, how often did they see the accused? The time factor and how often goes together, because we know that obviously with daytime, we may have sufficient light, and with that, we can say that visibility was not really an issue. But if an incident happened in the night, unfortunately things are worse now with this load shedding. Once it's load shedding, it's complete darkness in most areas. So that would also be a factor that we would be in. Who's speaking, guys? Please mute. Sandra, please mute. So, Sandra, please mute. Thank you. So, we check also, like if they say they know each other. Ladies and gentlemen, I think you can agree with me that, okay, maybe because I'm too senior in age, I don't know. But like there are people that I went to primary school with, for example. Some of them, I don't even remember them. When I meet them, they come to me and they'll be like, Elsie, you don't remember me. Remember, we went to the same school. Our class teacher was so and so. I'll be like, okay. You know, when you hear that, okay, you know that person is lying. So there are people who have very good memories, and some they don't have such good memories like me, especially if I don't see you often enough. My memory, I quickly forget, you know. So we check on things like how often do you see each other, the level of interaction. If you say you knew me when I was 12 years old, did we even speak when we were at that age? You know, so yeah, you have to check the level of interaction. If it's someone that you say, you know, the witness says that we lived in the same area, we grew up together. Yeah, this is the one. They say we grew up together and I know him from the area. Okay, you know him from the area. How often would you even speak to them? Because there is this thing called look-alike. People look alike. So have you ever even held a conversation with them, or it was just hi, hi, you know? So the opportunity for observation, we check. I did talk about the time of day, whether it's day or night. Lights, if there's, you know, fortunately any lights that are illuminating the area, we check what kind of lights was there at the scene. Was it your normal street lights or house, you know, how lights that are coming from the houses? As we know that some houses have lights on their fences, on their walls, actually, you know, and how far were you? Proximity. How far were you from the nearest light, from where you were standing or where the incident took place, so that we can be able to determine whether it was bright enough for you to can make a clear observation. Circumstances of the observation. We check, is this a moving scene or it was a stationary scene? When we say a moving scene, we are referring to, for instance, with hijackings, because there it's quick, jump in, point a gun, come out, you know, or those heists, you know, those kind of offenses we know even from the movies that you watch, which at least they shed a lot of light about scenes of a crime. You can see that things happen fairly quickly at such a scene. If you know it's a house robbery, then you can, at least if there's issues where there's no issues of the people maybe wearing gloves and maybe masks to hide their faces, then you check how long were these people in the house, you know, and did they talk to the victims, you know, did how many of them, of the perpetrators, were involved in this crime, and the reason why the accused is standing out as the one that is being identified from the others. What was the position of the accused? Were they standing in front? Were they standing on the side? Were they standing at the back, keeping a lookout? You know, what role did the accused play? Who did the talking? And also important, if there was more than one perpetrator, it is important to also get, even if it's not a lot of description of the others, but some description at least would help to show that this accused is not being unfairly targeted. Maybe at least some complexion to say this is how tall they were light-skinned, or they were of this kind of body build, they were wearing this color of clothes, so at least something, that can show that this person had ample opportunity to make, a clear observation. Fear and stress are factors that we always consider during a commission of the crime, because things can happen unexpectedly and suddenly. So that element of surprise comes with shock. This person who's giving this evidence of this identity, their state of mind, it was not like they are chilling like us now. We are cool, we are not stressed in any way. This person is pointed with guns and threatened, with death, or maybe being cut up, and, yeah, the most horrific things are happening at the time when this incident is happening. We have to check the fear and the stress levels. We check whether this has in any way played a factor in their ability to can make a clear observation, and any other concerns that you have. The position of this witness who's making this identification also, and with regards to the description, we check. As per the police statement that has been given, is there any exceptional features? So this would now mean you have to know your clients very well. And if they have anything that is exceptional about their features, which ought to have been noticed by the identifying witness, was it mentioned in their police statement? Not only just clothes and disguises, if they were having any, but if they have scars and, a very, big eyes, for instance, because there are people who just have, such big protruding eyes that, like, I'm not trying to be, or whatever body build, something that is just making them to stand out, that needs to be given in the description that is given to the police. And if it's something that is so blatant, then we would question, why was it not mentioned when the incident was just new in the mind of this witness, that it's something that they should have also mentioned amongst all that happened there. That the reason why I particularly remember this person is because they had this feature about them, and that makes them to stand out. Okay. Why? The reason why a witness or the police are suspecting the accused, we check. Is it because there was a discussion with other people, or based on information that was given to the police to go after the accused? So here we are talking about your common offenses like housebreaking in a particular area. You would have a group of, I'm sorry guys, I'm making an example, particularly boys that are known to be maybe a group of drug addicts. And because of their drug habits, they are known in the area for being the ones who would generally break into people's homes, and that is to feed the habit, the drug habit. So the intention is to break in, steal, and then go sell the items that they have stolen. So did the police go after these people because of that general knowledge in the area and that information being assimilated to the police? So basically, there wasn't really anything of substance that led the police linking the accused to the commission of the crime. But because of the stigma that is attached to these people, then the police are led to them. That is something that obviously then we would then have to establish that apart from that, did they have anything else that links the accused to the commission of the crime? You cannot just rely on this one. He's a well-known, person who is usually prone to commit this kind of offense. There must be some other kind of evidence that leads you to think that they are the one. Okay, so with the parades, ladies and gentlemen, you can have positive results and negative results. If you have a positive results in identity parade, ladies and gentlemen, you still look for corroboration of other evidence. So a positive result does not mean is the end of the case. You look for corroboration. Police have a guide on how they conduct the parades. This is not the rules of law. It's just based on their practices as the police over the years, how they have conducted the parades. So you will look at the parade, how it was conducted from a form that they complete, and sometimes they may give you photographs and videos to see what has happened, because sometimes the parade, they happen that the lawyer is not there. The investigating officer should not come to that parade. And it's for obvious reasons, because he knows or she knows the accused. The investigating officer knows the state witnesses and the information that they have on the case. So we are trying to eliminate any influence. Suspect is going to be informed that they can elect not to partake in the parade, but if they do, such refusal can be used against them later in the court. A minimum of 8 persons should be on the lineup, but not more than one suspect in the same case. So this is where you have maybe 2 accused in the same case. Both of them should not be with those making up the 8 people. So 2 suspects in the same lineup, that's wrong. It shouldn't be like that. So with identity, we will check the height, the build, the appearance, the job of this person, if they have a job or whatever occupation that they do, the dress, and you check whether the suspect can choose a position. Oh, so sorry. The suspect can choose on the lineup where they would want to stand. If they want to change even the clothes that they are wearing during the parade, they can choose to change the clothes, they can change the position and make any other request that will be acceptable to the officer who's running the parade. Witnesses will be separated at this parade. No discussion must take place between them. They will be separated even as they come in and when they go out of the place where the conducting of this parade is taking place. Witnesses should say at the end of the parade whether they are able to identify or they cannot make any identification of anyone who's on the lineup. The forms will reflect that the identification was made from this time, the witness took this long to make an observation, and at the end, they were able to positively or negative result out of that parade. This parade should be held out of sight, no entry, no exit during the parade, no witnesses should see the suspects before the parade. One last important thing that I want to say about identity parades. In practice, how they happen, ladies and gentlemen, that is why it's important for lawyers to be there, if you can. How they make up the parade, they just pick people who are already in the holding cells. So these are people who are arrested for different cases. And if they need to conduct a parade, they take just, some people who are there on the lineup. And I can tell you, ladies and gentlemen, the idea with an identity parade is that similar looking kind of people should be on the lineup. Lookalikes should be on the lineup. And if out of that, you now end up with a positive identification, then we can certainly say without, much doubt that this witness did not make a mistake. If these people were so much looking alike, but despite the similarities in how the people look, this witness was still able to pick the correct accused out of that lineup. Now, I plead with you, if you can, I don't know how, but yeah, maybe with practice, maybe that you can see those pictures, because they take pride in sharing the pictures with the defense, especially where the parade was positive, because when you get to court, they will tell you, please don't waste my time. I already have the guy, even our identity parade was positive. So that is to make you go weak, to tell you that don't come and waste my time. I have a watertight case. That's what the prosecutors would tell you. Please, that is why I plead that if you can, go to that parade, and the first thing you will notice when you get there, you will remember me, because you will see the people on the lineup, they may maybe be all of them black males, as an example. They will be having different body sizes. They will be of different height. They will be having different complexion. They will be having different hairstyles. They will be wearing different kinds of clothes, because I told you, they don't take the trouble. And I understand that SAPS is pressed for resources, that it will become difficult for them to make everyone to wear black jeans and black t-shirts just for the lineup. So they will just pick people who are there in the cells, and these people guaranteed they are wearing different kind of clothes, they are having different skin tones, they are having different hairstyles, body builds and whatever, and they will be so proud at the end to say, bam, here's the picture of the one who was pointed out, and it is your client. Of course, but if you want to be able to challenge that the evidence of this identification, that is what you need to show, that this person, it's not surprising that they've been picked out, because from the facts we knew that they are looking for this kind of a person, and it's exactly the description that fits that of the accused. But the people who were on the lineup, they did not look anything like the accused. So that's how you would be dealing with it. And I tell you, when we are dealing with presentation of evidence, this is how you should challenge it, because the better you know your client, you should even ask them to smile, like really show you if they have teeth or they don't have teeth, because those are identification marks. Sometimes the only person who doesn't have teeth on the lineup, who talks with a rough voice like pitch black afro, if you know that rapper, that guy looked rough. He had the darkest skin tone. He would have dreadlocks. He had scars on his face. So if you put that kind of a black male on a lineup, you should have lookalikes on the lineup. And I'm not making a joke. So I want to close this topic of identification to say it is very important. I'm telling you, if you are going to get into the field of criminal court practice, this is a daily bread. This is the daily fight about identification that is made by someone who says, I saw. And you will find that human fallibility is a real issue. It's a real problem. People make mistakes, even if they know each other. Sometimes we see it a lot. Like, I think, TV and all this, exposure that we get through the media has shown us that, for instance, these celebrities, for instance, in America, for instance, they call them body double, someone who just looks so much alike like them. So we know that people do look alike, and it is common for people, not that they had bad intentions. We understand the trauma and everything that people go through when these crimes are perpetuated, but the truth is we cannot disregard the fact that human beings make mistakes. Thank you. Do we have any questions, any comments, any inputs, any takeaways? I'm going to introduce new slides.
Elsie,
Please.
I have a question.
Yes, go ahead.
As you said, as a defense attorney, when you are observing the ID parade, and you mentioned something about, requesting that, the teeth of the people in the lineup are shown, would that not amount to being interfering, or is that just something that you note down in order to challenge that ID parade?
That information is important because you check the statement of that witness that they made immediately after the incident. That happens before the ID parade. So if they had noticed that this person had no teeth, or the tooth, they were so black and crooked and whatever, they look like vampire teeth, that is something that will be in their initial statement, in their police statement. Now, come to court. All of a sudden, you look at your client. He looks like he has this, I think they're called veneers, or what are they called? Those fancy teeth that people put nowadays. Those fancy teeth, they look like they're natural teeth, but they're so beautiful. And you're like, but this witness in their statement wrote about someone who has the most horrific looking teeth. And even at court, the accused in court doesn't have those teeth. So that's how you would introduce that. Or if the accused has those bad looking teeth, then you would ask the witness that, I hear you, ma'am, mentioning, all the other things about, the description of the person who attacked you. Did you particularly notice anything about their dental formula? The witness would probably say, no. Then you place it to them that the accused has the most horrific looking, ugliest, blackest, what are the cavities showing and stuff on their teeth. How come you didn't see cracked teeth and in their mouth? Because that is the person who is before court. That is the very first thing, once they open their mouth and they talk to you, that you see that these teeth high. No. So how come? That is a very distinct feature. that you did not mention to the police, and it's something that is blatant, how come? That is how you would bring it up, Riabetu.
Perfect. Thank you so much, Elsie.
You're welcome.
Understandable.
Oh yeah, somebody says veneers. Is it veneers or what? I don't know, guys. I'm not a dentist now. Yeah, but I think they're called veneers. I don't know. So you are more knowledgeable with those things because I'm not interested in, yeah, those, yeah, but that's how you bring it up. So, okay, someone still confirms they're veneers. So I was right. Thank you. So that is identity, ladies and gentlemen. We challenge it because if you don't, your guy is going down because the prosecutor has, yeah. Mpo, do you want to say something? Please speak up.
Yes, ma'am.
Yes.
Okay. Mpho Motaung, yeah.
Yes, Mpo.
I just want to find out, ma'am, without sounding, I don't know if my question will sound stupid. Now, can a blind person be brought for an identification in circumstances where maybe she can identify the perpetrator via smell or anything of that sort? And in addition, I just want to know if ever maybe that we never complainant didn't see the person's face, but he has a maybe a scar somewhere which she can identify. In such cases, how would we go about conducting the identification?
Okay, Mpo,
Thank you.
clarify for me. Is this a two-part question?
Yes, ma'am.
Can a blind person make an identification
Yes, ma'am.
through sounds
Yes, send the
and
person.
smell?
Yes.
Yes, if they can. It's identification, it's identification. So obviously, you will challenge it in the similar way when I say human beings make mistakes. Then you will have to go to depth to know how come they knew this smell, you understand, to be the one that belongs to the accused. Because was it a soap? Was it a perfume? What is it that makes you to identify or somehow relate that smell to the accused? So yes, it's possible for a blind person to come and be an identifying, but the state also, you can maybe in your representations to them and say, look, really, if this is the only evidence you have, you're gonna have a tough time because you're gonna get challenged seriously. Obvious, they have to have other type of evidence to support that blind person.
Okay.
Corroboration is important. Yeah. So your second part of the question was,
In terms of maybe a distinct feature like a scar.
seen by the blind person or someone who can see.
Let's say the person didn't see the actual face, but maybe they got the build and a distinct feature like a scar, or I don't know, maybe they had a crooked hand or something.
Is this still the blind witness who's giving this information, or you mean someone
No,
who can see?
yes, somebody who can see.
Okay.
They didn't see the person's face. They just
Okay.
maybe saw a part of them that maybe had a scar or something that they
Okay.
can identify.
No. We get that a lot with people who say, especially about the clothing, you know, we get that a lot about the clothing because especially where the incident has just happened. And then the witness will say, you know what, I did look at them, but I can't say much about how they look like, but I can tell you they were of this race, this complexion, and I can't say too much about their body build, but I can tell you what they were wearing, and I can confirm that, in fact, shortly after the incident, the same people were accosted, maybe by securities or police. And when they were brought to me, I was able to say, yes, these are the people who had just who had just attacked me.
Okay.
We get that a lot. So when you get that, that's when you have to dig deeper and say, yeah, fine, we accept that. Even the accused confirmed that indeed they were arrested wearing the same clothes that you are talking about. Green t-shirt, yellow pants. But on a day, how many people on the street happen to walk up and down the streets wearing the same colors? You understand? So you have to be able to give more than just, the height, and because we need more. We just need more. We can't just rely on the clothes. And of course, with clothes, we know that people can even take off. If maybe they were wearing layers, they can take off one layer of clothing, throw it in the bin as they are running, and they are now even passing the same place, because you can even ask them and say, so because the same person who you say was your attacker, you really didn't have an opportunity to look at the front part of their face. Maybe you saw a side of their face where you say you saw a scar, right? And now this, if this same person was to pass right next to you, with different types of clothing, were you going to be able to say this is the same person? So you can't just place reliance only on clothing. That is why there's caution that is applied when we're dealing with that kind of evidence.
Okay, no, I get it. Thanks a million, man.
You are welcome. Yeah, so tattoos and whatever, those are distinct features. Give us more. Give us more. What makes you say without a shadow of the doubt, this is the person? That's what we are going for. Okay. No, no mabongwa.
Hello,
Hello.
can you hear me?
Yes, we can.
Oh, okay. I'm sorry. I'm not sure if you've covered this. I've just joined the class a few minutes ago.
Mm.
I just wanted to find out, ma'am, what then happens? Let's say we then discover that the victim identified an incorrect person. Can they be brought to task for that, or the court would just take it as a mere mistake? That's number one. And number two, I'd like to relate it to a personal event. I got hijacked a few years ago, and then the investigating officers, because I couldn't see the people, they were like, you know
Yeah.
what, we've got people in custody for the same offense, so we need you to identify the same people that did the other offense so that we can tighten up our case. Obviously, it did not sit well with me, and I did not agree to that. But then what then happens if you then find out that the investigating officer were in cahoots, so to speak, with the victim to identify a certain person, your client in this case?
That happens a lot, especially with the in custody. I remember there was a time, even I know it's still ongoing. If you have a client who's in custody and you want to go to the prison to do consultation, remember, that's the only place where you can go and prepare for your trial. When you get there, the correctional officers, they use some loudspeakers inside the prison to call out the names who are having legal visits. So we noticed that, no, man, we keep going to prison. Every time this police, they will come back and they will say, the client did not respond. Okay. So we had to devise a new system to ensure that, they will answer. But we had to understand, why is it sometimes you go 2 times, 3 times, they will say no response, no response, no response. But we know for sure that the person is in custody. And you remember what I said, in prison, there's a community. That means information gets shared. So we later found out that they have been telling each other that they shouldn't respond when those calls are made, because when they call them, they just call Mpomutaung. They don't say Mpomutaung legal visit, meaning your lawyer is here. No. Or they don't say Mpomutaung investigating officer is here. You understand? Or they don't say what kind of a visit are you getting. They just call you, you have to come out. So it turned out that a lot of people, the police would come to the prison, call them out, and when they come out, they are now placed on arrest for further charges. So it became a habit now that they don't respond. So the only way you would get your client to respond is to tell them, please note, I'm going to come and see you at prison on this day. Please respond. You know, because there is a tendency within the police force that they gather evidence of a, it's not always syndicates, but to them everything is syndicate, you know. So similar type of offenses, they would now group it together, and they will also profile, because they use a profiling system to record the people that get arrested. So they use that profile to pick up people who are arrested for similar type of offenses. So if it's your hijackings, your bank robberies, your heists, they will now pick the people, and they will randomly conduct these ID parades with victims of those types of offenses, to just, by some chance of luck, to test whether those victims will be able to point anyone. Sometimes then they will have some positive identities coming out. And when you dig and ask, how did they get to you? And then you find out that is how they got to them. So I'm glad that you didn't go there, but I'm also glad that you bring this up, Mpho, because you remember that example that I was giving of the boys who are known in the neighborhood for being the ones who are known for committing housebreakings. Character evidence cannot stand in court. In fact, we must challenge it, because the case that comes before court, it must be based on facts. You cannot come in and charge somebody because they work with a particular group of people who are known to be this kind of people. So yeah. But yeah, that is the practice within the police force, that they obviously do that with the hope that if maybe an identity can come out of that parade, a positive ID, then they join the dockets, and now they bring a stack of dockets that is high to the prosecutor and say, add additional, charges for this person. That's the practice. You'll have to deal with it as the lawyer on record. Richard, I see your hand is up.
Thanks, Ma'am Elsie. There's 2 points I want to raise. The first point that I want to raise is sorry for the dog barking. The first point I want to raise is on the section C. I know we went last night, we dealt with the SMP 5 of the docket. And I just want to maybe, there is a decided case on that with the Panihoti case. We had access to the part C of the docket.
Maybe what you can do for us, Richard, type in the full citation of the case for us, which would be a good to share.
Yeah.
Yeah, in the comments.
So I just want to say lawyers do have access to part C of the docket. And the reason why I'm saying that is because the part C links to a police officer's pocketbook or the diary, if he's a commissioned officer, and the occurrence book, the book in the charge office that they make notes. And we've seen it now in the Blue Light Brigade on the N1.
Yeah, that case of the bodyguard.
Yes, and they're disputing the entries in the pocketbooks and in the diaries of the commission officer, as well as the occurrence book. So I will share that Panihoti case. It was the first case ever where that case, you had access to part C, the SMP 5 of the docket.
We'll appreciate.
Yeah, I will share now the link. In the identification parade on page 41, paragraph 2.5.1 on identification parades, and speak in accordance with Section 37(1)(b) of the CPA, okay, the Criminal Procedure Act. They say there a suspect is obliged to attend. Now, last night we've touched on the peace officer and a police officer. Now, a suspect is not arrested yet. And the second part of this says, is obliged to attend an identification parade whether he is under arrest, on bail, or warning. Now, if you go look at Section 37, and I don't want to go into detail, I'm just worried about if a person is a suspect. Is he obliged? He's not arrested. He's standing on a street corner and they say, here's a man with a green t-shirt. How are you going to put him on an identification parade if the manual says, if he is a suspect? And if you go look at 37(1)(b) of the CPA, I'm just worried about what is said in the manual. If you're a suspect, or whether you've been arrested or not. And my question to you, ma'am, is, if you're a suspect, you're not arrested, can you appear on identification parade? Thanks.
If you are a suspect, you have not been placed under arrest, you are just like you and me. So what right or which law will they use to force me from my house to say you have to come with us to put you, unless if they ask me, because I'm not under arrest. Remember, when you are under arrest, you are under their custody.
I fully agree with you, but it says a suspect. Now,
that is why I'm saying you have
a
to
suspect
establish.
is not arrested.
That is why I'm saying if a person is arrested, it's a different case because you are under police custody. They can control your freedom of movement, where you go, and so you are under their, so the only way out is if they grant you police bail or prosecutor bail. You are under police custody. That is why if they ask you to do anything, you have a right to ask them, am I just a suspect or am I under arrest? So that you can determine whether you can refuse to subject yourself to certain things or not.
So the manual must maybe
I'm not the compiler. Let me just say for the record, I'm not the compiler of the manual, but maybe the manual should.
So the compiler, I don't know, Zuki's there, is to just look at, I see Dr. Llewellyn Curl Lewis was a compiler. We should look at the word suspect in paragraph 2.5.1, because if you're suspect, police cannot even take your fingerprints or you put you on identification parade. And maybe they should just maybe rephrase that paragraph in the manual going forward for the next semester. Thanks, ma'am.
Maybe drop an email also as well while you are noting it specifically like that. And I will also, because they need to, and I think for some time now they haven't actually reworked the manual, so maybe it's time, like you are picking it up. But what I am happy to hear you picking up is that now you see that is why I told you the rights that we've been making noise about, they apply to arrested persons. So I've been clear from the outset that Section 35 doesn't talk about suspects. We are talking here about people who are under arrest. And when we spoke about the peace officer, I made it clear that who can put you under arrest. So we are talking about arrested persons.
Yeah.
So yeah, so
Because
yeah,
even the second paragraph, sorry, and I'm keeping the clause up. The second paragraph says it is a rule of police practice that suspects who take part in identification parade should be informed of their rights to their
yes,
legal representation. You cannot
yes,
put a suspect.
no,
Yeah, thanks,
no.
man.
Yeah. Thank you, Richard. Thank you so much. Solo Fellow's hand is still up. I don't know if you forgot it. If you say that a suspect is obliged, maybe you should tell us what obliges them, because obliged is a very strong word. That is how the state gets sued. Because if I'm not arrested, you can't treat me as an arrested person. I'm just a suspect. So I can decide even to walk out and you can't stop me. I'm not under arrest.
Yeah, and thanks for that also, ma'am. And that's where the judges' rules kick in. You know, we will maybe deal with the judges' rules later of 1976. Yeah.
Mm. Mm. Yeah, it's good to read and really to know these things, because people take things like lightly. And that is why when I spoke and I said very simple things, like when you see someone who bears the title of officer, everyone just thinks I must submit. But we need to know what powers do you have and what can you do that and what you cannot do with your uniform and your donkey PD and your whatever, you know. Okay, so Tulufela
Hello.
seemingly doesn't want to speak. We
Hello,
move.
can you hear me?
Yes.
Yes, Tulufelo here,
Oh,
Elsie.
okay.
I,
Okay.
sorry, I
Mm,
wanted to comment on the identity parade issue.
mm,
Um, I've noticed, I do work as a prosecutor. I'm quite new
mm,
to the field, and I do
mm,
notice, as you've stated, that
mm,
they just take people from the cells,
mm,
and they don't really take the time to go. Remember, they have to take people who look, like we said, who
mm,
look the same,
mm.
and most lawyers don't really challenge that. That's what I've noticed,
No.
because it's quite amazing, because remember, as prosecutors, we receive all the documentation and the pictures, as you've said, but they
Mm.
don't challenge it. I mean, that could be the difference between your client walking and being inside. They don't, because most don't even attend it.
They are informed in court
Yes.
when the matter is under investigations that, your worship, this matter is being postponed because the state needs to conduct an identity parade. You are already on record. You won't bother to go.
Precisely. So if I was on the other side, I would actually do something about it, but they don't, and it's quite amazing. Hey, that was just my 2 cents worth.
Thank you so
Thank
much,
you.
Sulu Fellow. Thanks for rubber stamping what I said. Because really, people just, I don't know, maybe you think you'll have to now charge extra. Of course you should. You should. If you need to attend an identity parade, charge extra. If you need to
Yes.
go and visit the scene of the crime to do an inspection in loco before you get to the trial, by
Mm,
all means, charge. That is why you are there, because you are going the extra mile. You are looking for the freedom of your client. So yeah,
yes.
let's not.
And I don't just want to get to a lot of politics, but the police, when it comes to a lot of investigative work, they're really failing the people. So yeah, there's a lot happening. No, thank you so much.
Thank you, Solufel. Thank you. Okay. So yeah, that is a mouthful there. So we move. The train moves to the next hot topic, ladies and gentlemen. It's hot also because it's another very, very troublesome one. We encounter it a lot in the courts. Searches and seizure. And I said, who can do this? The peace officer. So when evidence of items seized is to be done, we check chapter 2 of the CPA. It's gonna give you a whole guiding set out, procedure that should be followed in terms of how this should be done. Now, often with seized items and articles, there is an issue surrounding their admissibility in court. The item is there. It's already even in court, and it's about to be even introduced as evidence. Now somebody will stand and say, no, this cannot be accepted as evidence by the court. So the admissibility is challenged. And this is because of failure to comply with the statutory provisions, which will now lead to this item having been found to have been unlawfully searched and seized. Disputes about admissibility of seized evidence. How do you deal with it? It happens in a trial within a trial, ladies and gentlemen. So the manner that this information was obtained will now have to be fully dealt with in that trial within a trial. So it's a normal trial. Maybe the complainant has come and said, I was walking down the street. That's a normal trial. And these people just came out of nowhere and they pointed a gun at me and they took my cell phone. They ran away. And then after they ran away, I was walking on the street crying, and securities maybe saw me and they asked me why I'm crying. And I told them I've just been robbed. And they said, who? And I pointed them to the direction that these boys they ran to. And I told them they're wearing maybe green and yellow pants and t-shirts. And they went, and not less than, 5 minutes, they come back with these people. And later now, the arresting, or rather the securities that apprehended these people will also come and say, yes, after the information we received, we followed that direction. We saw someone who fitted the description given to us. We stopped and we asked to search. They agreed, and we found the items. So if you have issues about how the search and the seizure would happen, then you go into a trial within a trial, because now you're going to lead evidence in detail of how that has happened. And after the evidence is dealt with, where the state will produce evidence of how that was done, the defense will have an opportunity to cross-examine, and then arguments would follow after all the evidence presented. The court must make a ruling whether that evidence was lawfully obtained, or it's going to make a finding that that evidence was unlawfully obtained, and it's not going to be accepted as evidence by the court because of the manner that it was obtained from whoever. That happens in a trial within a trial. So there's a very strong link, ladies and gentlemen, between these searches and seizures and the provisions of the Constitution, because the challenge in the balancing of the rights of everyone, as we all have them in terms of the Constitution, it clashes with the provisions of Section 19 and Chapter 2 of the Criminal Procedure Act. Now, here we are talking about, can you submit yourself to being searched, or do you have a right to refuse to be searched or not? So, your right to dignity, if you are searched, you can say my right of dignity, it's not respected or protected, as Section 12 of the Bill of Rights states. You can say that my right to freedom and security of the person, which includes the right not to be treated in a cruel or inhuman or degrading manner, is also encroached upon. the right to bodily and psychological integrity, which includes the right, the right of security and control over your body, is often what you would raise when you say you didn't have a right to search me. You violated my rights to bodily integrity, my, security, and I felt violated, basically. So yes, you have all those rights. Your right to privacy. And oh, guys, please, who is that? I can't see. Please mute. The right to privacy, which includes the right not to have the person, your home, your property searched, and your possessions seized. You can raise section 14. The subsections are there. Section 35(5) of the Constitution says any evidence obtained in a manner that violates any right in the Bill of Rights must be excluded if that admission of that evidence would render the trial unfair or otherwise detrimental to the administration of justice. But with all these rights, ladies and gentlemen, keep in mind that there is still the ugly Section 36, which is the limitation clause that says now you cannot refuse to subject yourself to searches under certain circumstances. For instance, okay, I'll come to that now. Let me not spoil the party. Section 28 to C of the CPA now requires the members of the police, and we are talking about peace officers who have the relevant authority here, né? Requires the members of the police to have only a reasonable suspicion or a belief before an article may be seized. So often in court, when the police are asked, why did you search this person? They will say, I had a reasonable suspicion that is in possession of, a weapon that is unlicensed or whatever. And that is all that is required. A reasonable suspicion, it's subjective. It means it's what they think. Are they right by thinking so, or they're not right? You will have to test it, but all they need is a reasonable, they formulate that conclusion that this one I suspect. And all that suspicion has to, it must just be reasonable. So it's also one of the most contentious issues in court when faced with the police to now say, really, there was nothing that was suspicious about this person, because look at it, this reasonable suspicion, it's also opening a door to personal prejudice. Like I told you in the example of our poor dirty guy that is standing maybe looking into a window of a shop. When you just look at that person, they look hungry, they look dirty. Why are they looking into that shop? Are they not allowed to admire the cakes that are rolling on that pedestal? Does it mean if they're dirty and they're smelly, it means that they're formulating an idea that they will later come and break into that shop and steal the cakes? So that reasonable suspicion, ladies and gentlemen, it is subjective. And for you to deal with it, you have to show that the personal bias of this officer did not cloud their judgment to unfairly, act out in a manner that it victimizes people who look in a particular way. So that is all they have to do, and tell the court that, to me, it looks suspicious and it was reasonable for me to believe that maybe they're about to commit some crime. But yeah, I think I've said enough there. So please note here, you have privileged documents that may not be seized unless the person in whom the privilege vests relinquishes that privilege. And documents that contain communications between a legal rep and client are subject to the legal professional privilege and thus may not be seized. So we can talk about what are legal documents, if ever they can be seized, what circumstances will lead to that happening when we say these are privileged documents that ordinarily would be covered by legal privilege. Can it ever happen that they become seized? Yes, Richard.
Sebi, I'm enjoying your topic because I'm more in the criminal than the civil. But soon I will enter the civil law.
Okay.
It's a very interesting topic, especially on privileged documents when it gets seized. I've been in a couple of situations where you do a search and seizure and the person claims privilege. And what we've done in those cases was we would approach the register of the court or the master of the High Court to seal those documents, and then during mediation or with dispute resolutions is to see what can be released from that. And what's important there is and we're dealing with criminal case law here, is we need to find out from the client when he claimed the privilege, when they opened his gram of his mother or a lever arch file, and the police wants to take that and he says privilege. That must be respected. And the police officers there, and it's important to find out from the client, did you claim privilege at that time when the documents were seized during the search and seizure? Yeah.
The question would be then, did the client even know that they could raise privilege? Because no matter the level, like I said, they are, level of whatever they do out there, if they are not legal practitioners, they are lay persons before the law. See?
True, eh? We have to educate our clients.
Yeah, it can be, I don't know who's the smartest person on earth, that everybody knows is the genius number one. You understand? Is knowledgeable in most difficult subjects, matters on earth. But when it comes to the law, they are lay person. So if you say they should raise that issue of privilege, you cannot hide behind the fact that they did not do it when the items were being taken, because they are lay people.
Yeah.
It's the attorney who obviously has to now come and say what you've taken, you cannot use it because it's covered by privilege. So you cannot put the blame and say you should have stopped us from taking it from your house, because you can simply say that I didn't know. I needed my lawyer to advise me that you are not allowed to take those documents.
Can you claim privilege after a search and seizure?
I say yes. Because
thank you.
yes, you can, because like the example you gave, If you are seizing things that you see, that these things will probably be raising privilege, and you decide to wrap those and seal them, it means you know that those are documents that you shouldn't even take.
Thank you.
But if the lawyer comes on board later, you have to return them. You can't use them as evidence. Okay, so we have to protect this legal privilege, ladies and gentlemen. And I think it's Mpo, maybe, the one who said she's a prosecutor. I'm talking here to people who are still going to start out with.
It's Sulu, ma'am.
It's Sulu. Thank you, Sulu. Yes, the ones who are still going to start out in the criminal courts, or they are still starting out, please look after this privilege, because I've seen how people just stand at the court passages and they will be discussing delicate issues about the cases that they are handling. Do you know, people could be sitting in, listening in, you know, that shouldn't happen. If you are discussing anything there while you wait for your case to be called at court, it should be about the weather, that we are all tired of this winter. When is it going? They're telling us another cold front is coming. That's what you should be discussing. Nothing about the case that can be quoted and used in court because you were careless, that you discussed things openly, you didn't protect your client. And also this thing of going to the cells, because a lot of times the lawyers go to the cells, and in those cells, it's packed in there. They would just be like calling out, Sipozwani, and Sipozwani, yes, raises their hand, and they will be discussing. Even if they say they are whispering, but people are there, they still hearing. So to me, you know, if I find myself in that situation, because sometimes the situation is pressing, what I do, I tell them, sorry, gents, I need to talk to my client. Push back, all of you, push back, sorry. You understand? I want privacy, so that now I have my moment with my client, then we can whisper there and I am okay. But this thing of just talking delicate issues in front of everyone, look out for it. Please, you are exposing your clients. It's not good. Don't be caught there. They won't be snacks. They won't be snacks. I'm telling you. They are all arrested persons. They all want to go home. So they're not going to be like, you can't tell us. No, they will move. You will just ask them, please, can I have a moment with my client? Just please shift back, please, please, please. And they move back. And then you whisper whatever you want to whisper to each other. And also, even in court, limit that thing of, may I approach my client, your worship, and you go on and you just turn your back to the presiding officer. And remember, when you are talking, the whole gallery is there facing you while you are busy there. No, man, you rather ask for the matter to stand down, and during the adjournment you go down there to the cells and talk whatever, but don't do it in open court, please. It looks bad, and it's very bad to do that. Makes you also look unprepared, unless if it's just an aspect, one aspect. And it also becomes irritating if you keep asking, can I approach my client, and then you are turning your back. It's rude also, even when it comes to court etiquette, to be turning your back every time. Can I also take instructions, your worship? You know, it's rude to do that. So yeah, I think you should. There's a course here, I think, called, what is it called again? That course that talks about all that. So if you're not ready to be addressing the court, then you shouldn't be doing that. When one question is asked, you go, and then you answer, yeah, my instructions are this. And then after another question, may I approach again? What?
It's trial advocacy, ma'am.
Trial advocacy, is it? Huh? Sorry, I missed that.
It's trial advocacy.
Yeah, it's coming. I think it's one of the courses where you're gonna, role play and do all that. So please watch out for those things. There may be just one aspect that you may just ask a quick indulgence, but let it not be like a full consultation now. Then you are unprepared. Okay. Okay, the power to search. Now, this search can happen. I'm trying to move Athalia. Yes. Athalia, you raised your hand. Are you saying something? Okay. So the search, ladies and gentlemen, it can happen with a warrant. Sorry, with a warrant. And police, when they do this, they comply with the provisions, or they have to comply. I have to say that because we know that there's a lot of non-compliance. They have to comply with the provisions of Section 21 and Section 25. I didn't put CPA on all this, but know that this is in terms of the CPA. If it's a search without a warrant, they have to comply with the provisions of Section 22. With consent, without consent, check also how, because there are people who just surrender, Private individuals, now I think it will address your CPFs, your Dudula. Please just read Section 24 and see what they can do and how far they can go. So I'm not particularly bothered there. You know how to read. I've given you the specific reference. A warrant for a search that happens with a warrant. A search warrant is obtained from a magistrate or a commissioned officer. Discretion to determine whether or not there must be reasonable grounds for them to want to go there to conduct the search. The discretion to decide whether those reasonable grounds exist or not. It will rest with the information given based on the information given to the magistrate. Then they will exercise their discretion to decide whether those reasonable grounds exist or not. We are still on Section 21. A warrant may be applied for before a judicial officer in chambers in terms of Section 29 of the National Prosecuting Authority Act. Now, the directives of the warrant, this is the important part now. The directives of the warrant must be strictly interpreted to protect individuals against excessive interference by the state or the police. Strict keyword. A decision to grant a warrant or not is based on that information that is contained in an affidavit or information that is given under oath by the police officer who's coming to ask for this warrant. Now, to state whether an article may be seized, if you want to know whether an article may be seized, please check the provisions of that Section 20. And where there are reasonable grounds to believe that the article is present at a particular address or a place, this must be clearly indicated on that affidavit. So for the one who's asking for the warrant, they must say, we have reasonable grounds to believe that the item we are looking for is located at a specific place. So there must be maybe a house number or address. And the article itself, if you give us this warrant, it's under the control of a particular person. So it means who they are hoping to find this article with they must say who is the person on the warrant. Search, Diana, please mute. Search to be conducted within the area of the jurisdiction of that judicial officer who is now granting the warrant. So if you are just to comply with jurisdiction. Now, a warrant must, like I indicated, in terms of section 21, it will have these specific directives. The name of the police official who is allowed to execute the warrant, the purpose of the search, the specific article they are going to seize, the address of the premises that is going to be searched, whether any person found on or at such premises may be searched. Please check these two cases. They dealt with the requirements for a valid search warrant and some guidelines in terms of the Minister of Safety and Security versus Van der Merwe. It has given us more guidelines on how this search with a warrant should be done. Polyphenes versus Minister of Police is another one. But the basic thing about the search warrant is that the warrant must be executed by day unless if specifically directed otherwise. So if it's not going to happen during the day, it will specifically say at night specifically say so. The warrant will be issued and executed on any day, which includes Sundays and public holidays. Only members of the South African police of any rank may execute there. It's not like with, confessions, only a captain and above can take that. So any ranking officer in the South African Police Services may execute a warrant. No private person. Remember section 24, guys, because I see you like CPF. No private person or forensic auditors may partake in the search. You see, I put question marks there to remind you about section 24 that says individuals also have some rights in terms of, some powers in terms of searches and seizure. Now, experts, maybe I'm noting you, experts may be present, but they may not participate in the search. Regard to decency and order must be observed. So a woman should be searched by a woman, a man by a man, and yeah. Okay.
Yes, thank you, ma'am. Now, in circumstances such as the famous television program where people are searching for drugs, under what authority would they be operating in terms of searching?
Can I tell you something? Maybe somebody here will answer us. I have a television in my house. It's always playing cartoons because my children, they are ruling the TV. So I don't know what you are talking about, honestly. Can you shed some light, maybe? What is this about?
Yes, it's a program called Sizokuthola. This private, I don't know if it's a security company, they are searching for drugs. And although they are in the presence of sometimes
Subs.
police, yes.
Are they going to do the searches in the company of subs?
Yes.
Then I think they will cover themselves with the fact that we just point what are they called, the houses where they smoke or sell drugs?
Yes.
Yeah, they just point the police to that house, and when they get there, they identify the people who are suspected to be trading with illegal drugs, and they may ask them to, submit themselves to be searched. If they agree or produce, maybe they ask them, do you have any drugs in your house? And if the person says yes, then they say, okay, bring it out. Or the police themselves, they can actually do the search because they've been led to that house under the suspicion that drugs are being sold at that house. So if SAPS is there, then they're going to be covered.
Understood.
If the SAPS are the one doing the search, not that security you are talking about.
No, in this instance, they are doing the searching themselves.
Really? On
Yes.
TV?
Yes.
I'm sure those cases they don't go to court, eh?
So I was just wondering, when I first saw the program, under what authority were they operating? Because here it says no private persons or forensic auditors may take part in the search.
Yes. And that's why I said, if you want to know more, read up on section 24, because those searches will be challenged in court if not done by a peace officer. And we have established that CPF is not qualifying as, those are just ordinary members of the community who just take it upon themselves to be looking after their community. So why can't they call the police if they've identified the house where they know that if we go there, we're going to find drugs? Then they should call the police and go with the police there. That's my view. Okay.
All right, thanks.
Tulufelo?
I just
Yeah,
wanted to
hi.
understand.
Hello.
Oh,
There's
there's
two
two
Tulufelos
Tulu's here.
here.
Yes.
Yeah. Okay.
Okay, you
Let's
can.
hear Bila first. Bila is number
Okay,
one.
sure.
Thank you.
Mhm.
I wanted to understand, in what instance would the peace officers come without a warrant? Because I've seen normally if they probably just come up to your house, you would say, where's your search warrant? So I just want to understand, in which instance would they have to search and they don't have a warrant?
They will say, because we have a reasonable suspicion that you have drugs here. And if we don't if we don't act now, you're going to dispose of the drugs. That's the next slide that I'm coming to explain when they act without a warrant. The sections are there to cover them, to say all they need to have is a reasonable suspicion, and I'm coming to that one. Bila. Let's call you
Oh.
Bila for the sake of
Yes,
confusion.
that's fine.
Yeah.
Oh, okay, because Elsie, that's actually what happens on the show Onkgopotse was talking about. It's
Mm,
mostly, yeah, these drugs. My understanding is that they do it with SAPs.
mm.
Yeah, it's
That
just
makes
that,
sense.
yeah, they do it with SAPs, and in most instances, they just after the drugs. So they'll get there and say, we've been informed you've got drugs, so you've got a gun in the house, and then the person denies, and then they start the search, and they actually find them, as far as in your plugs, in your garden, all these drugs will come out.
Oh, yo, hectic, eh?
Yeah.
Oh, I'm missing out, man. These kids must grow fast, yo. Okay. Tulufelo, let's hear.
Yes, I've also heard about the show and that
Mm,
they go with police, but the people who actually search, I think it's the guy who presents the show himself. So based on that, those kind of, or rather the contents on the show or the matters, we can't prosecute those things because first of all, the chain evidence of the drugs is tainted because
yeah,
police were not the ones who were conducting. So I don't know what they do to dispose of them, but we can't prosecute those things. I don't know after the show what they do, or it's just for sensationalism. We cannot prosecute those ones because from the start, the evidence is tainted because they don't properly
Chain of
secure them,
custody.
and the police.
Mm,
Yes, Exactly. So that's just
Mm.
for sensationalism. That show is quite
For
interesting. But
views.
with
That's what
regards
they call it, for views.
for views, but with regards to prosecution, those guys walk. You can't do anything.
No, but then they're actually doing an what they're doing is a good thing, Shem. But now they're
Yes, but
missing that very
properly.
important.
Yes,
Yeah, they should just
they
call the
should do it
police and
properly.
because I'm sure they
Okay.
have insider information. They wouldn't just pounce on a house that has no drugs. If they go to a house, they are guaranteed with their information that no doubt we're gonna find drugs. So they should just let the police take over immediately when they
Yeah.
get there. Mm.
No, that's just for sensationalism and show. You can't prosecute those ones.
Wow.
It's a
Okay.
funny show. Actually. Thank you.
Wow. Thank you. Thank you. Okay, Skumbuzo.
Evening, Elsie.
Hi, Kumbuzo.
Yes, I just want to find out what's your comments regarding the searches that you normally find when you are in retail shops, like you're searching of your shopping bags, like your plastics, your sleeves. What's your comments on that? Is it like illegal to do that for security personnel, like to search your groceries, like
Mm.
make you feel like you're suspects? Because I've heard it like a scenario whereby I refuse to be searched on a retail shop some other
Mm.
day, and
Mm.
all the
And-
manager like why I'm being looked at as a criminal, and
Mm.
the manager like to call the supervisor of the security guards and ask for forgiveness to me, like, cause I didn't take it well. So what's your
Mm.
on being searched when you're like doing your groceries or on retail stores? Like, what's your comments on that? Is it legal for security guards and shop owners like to search your bags?
Your
Like,
person. Mm.
yes,
Look, you remember when we spoke about the peace officer thing, and I told you there is a lot of cases that the security cluster, the security guards have been taken to court wanting to be given that recognition as, or also that authority to be extended to them as peace officers. But up until today, there's no court in this country that has agreed that they will fit the title of a peace officer because they belong to the private cluster and they have their own ways and trainings and which are not particularly, regulated by the government, as in like with the other law enforcement uh, agencies. So security personnel, they are private body regulated by their own regulating bodies. Now, when it comes to you going to a mall, for instance, and they want to subject you to a search, from their point of view, they would say before you enter any of their establishment, a right of admission is reserved. It means it's private property. That whole center, shopping center, it's private property. And the shop you are entering forms part of private property. And if they want to regulate who has access of who comes in there and who goes out of there, and they have to also use security for, the security guards for security purposes, they will say they are entitled to do so because it's for safety reasons, because we know the malls get robbed and. So they will heavily rely on the fact that it's private property. If you choose to come to that mall, you are surrendering yourself to their rules because it's like you coming to my house now. And before you gain entry into my house, I tell you, please leave your shoes outside. In my house, I don't allow shoes. If you feel insulted by my statement, you can choose to turn your back and go. Or if you see the reason, when I tell you I don't want germs in my house, that's why I'm asking you to leave your shoes there. Then you will surrender yourself and leave your shoes by the door. So I'm not saying they are right, Kumbuzo. I'm not saying they are wrong. And it's up to you as the person. It's up to you.
Can
It's
I
up
just
to you.
Yes. Can I interject there?
Why are you interjecting? Because I didn't interject when you were talking. I'm still trying to answer you.
Point. I just want to add to the point that you're making. So we did this in contract law, where that admission, right of admission reserved, qualifies what you're saying. So when they have the sign outside, so that you are subject to their rules when you enter. So they have the right to reserve who enters into their premises.
But who's speaking now? I thought I'm still talking to Kumbuzo. I'm confused. So I'm adding now Kumbuzo to say every of those places, whether malls generally, they will have a little signboard somewhere on a wall or on the floor somewhere that says right of admission is reserved. And literally, if you go into what the one who just spoke, just said, is their rules. Like I'm making my example with my house to say that in my house, this is what I allow and this is what I don't allow. If you don't feel comfortable, you are welcome to leave. If you enter my house, you're going to be subjected to my rules. So if you want to talk legalese, then they were polite when they then apologized to you because they applied the rules of, what do they say about customer is always right, whatever, that's why they apologize to you. But if for them asking to search you and you refusing, I don't know, maybe if somebody else disagrees, but if they can raise that in your face and say, you have entered this premises fully aware that this is private property and this is how we keep order in this property by having our security search and yeah. So if you're not happy, we are not forcing you, but you can leave. But you can't refuse to be searched because we are concerned about safety. That's why we put security there.
Okay, well noted. Okay, in the case that you are paying search and nothing is found in your possession, like
Then
the humiliation that's like,
that's
can you
that's why they will say if you feel humiliated, then you leave. I don't know if this is when you are entering or when you are leaving the shop,
when you are
because
leaving
I've never seen the only people the only thing I've seen happening in the shops is they will ask to search the plastic if you bought something in the shop to just verify with the receipt that the items as per the receipt are all what is in the bag. I don't know.
Okay.
For theft purposes.
What if they don't find anything in your possession while they body search you in public? Can you open a charge against?
That? Why will they do that? They're not supposed to do that. They're not supposed to body search you in public. If they suspect that you have stolen, now Skumbuso, let's be straightforward. If they suspect that you have stolen something, they can't body search you in front of everyone. They can ask you to follow them to a back office. In that office, they will tell you, look, maybe through camera or maybe one of our security observed you as you were hiding items in your bag or in your pocket. We think that you have something stolen on you, that you were about to leave the shop without paying. So at this point, we have to ask you to come with us. We're going to call the police to come and search you and establish if really there's anything.
Okay.
That is the procedure that they're supposed to follow. They can't search you.
Okay.
Body search.
Okay. If they do, then they don't find anything, you can open a charge against them then.
Which charge? Criminal
Like-
charge?
Yes, like they violated your right, like
No, they are
probably
rich. Sue them. Sue them for money, man. Why do you want them to go to jail? They are rich. Sue them. Go
all
and get
right.
money.
All right, thanks.
It's not worth them going to jail. We want money most. That's why we are here. Sue them for money, for the humiliation, like you say. Hmm? Get money out of them. Plus, their cameras will show how the whole incident played out. We can even have maybe someone who's with you video the whole thing and go and show it, even take them to the highest court in the land so that the money that you get for, that whole, embarrassment will suit the shame that you faced, Yeah.
Okay.
Okay, let's move, ladies and gentlemen. 10 to 7. I aimed to finish by 8. Can I just move to the other slides? I think we are clear. Mbali? Mbali's covered. Thank you, Skumbuzo.
Yes,
Thank you,
no, I'm
Mbali.
yet covered.
Hmm?
No, I'm not yet covered. I'm not yet covered. Mm.
Okay.
As we are speaking of the show of Zoptola, we all know that the presenter guy is also a policeman,
I
and
don't know.
he's
I don't know.
oh,
I don't even
all
know
right.
him. Okay.
Okay, he's a policeman, and he's also accompanied by the law. And so my question is, so if they've come into my house with a search warrant, do I have the right to refuse?
You only refuse if you've read the search warrant and there's something that you disagree with in the search warrant. Otherwise, if it's clear as to what they want, who they're supposed to search, what they're supposed to search, you have to subject yourself to the search. As I told you, here, look at this. Section 21, subsection 1A. Please read all those subsections that will say the name of the officer, the purpose of the search, specific article that they are looking for, the address of the premises. Even sometimes it will say who they are supposed to find having control of the article, and whether any other person they find in that house may also be searched while they are there. So I told you, with a search warrant, we interpret what is contained in the warrant, the directives. They must be strictly interpreted, meaning they must comply with what is strictly written on the warrant. So if it is not in the warrant, then they can't do it. Simple.
Okay. As I'm one of the followers who watches the show each and every Sunday, I've seen many of the victims after break, they are confessing, and they are showing them where do they keep their drugs. So the last question which I would like to ask, what do the policemen use or do to the victims? Do they beat them up, or do they use such of the electronics what for them to confess or to speak the truth? What are they using? Which
If they beat,
resources are they
if
using?
they are beating them up and they after the beating, then comes the confession. That confession is an unlawful confession. It cannot be admitted as evidence by the court. Ne? Because a confession must be
Which
done voluntarily without any force, any pressure put on the person to make that kind of a confession.
oh,
If you
okay.
even
But-
minimum force with a confession, no.
Mm.
The requirements for a confession are that this person must be free and they must be doing this voluntarily without any undue pressure. Do you understand? So if you say minimum force, no, it won't stand.
All right. Thank you, Elsie. I get it.
All right. I think we're going to
Sure.
close with Richard. Richard?
Yes, thanks, ma'am. If you can just go to slide 18 for me, please.
All right.
On slide 18, you say no private person or forensic auditor may take part in the search.
Take part, as in open your drawers and
take part in the search, may take part. Okay. Now, there, I just want to, I might be wrong or might be right, or I might never be right or never be wrong, is a lot of law enforcement agencies work closely with forensic auditors, closely with forensic investigation companies.
Yes.
And when a search warrant is being executed, you have to submit an affidavit to the judge or to the magistrate, where you outline in that warrant who's going to be part, whether it's in terms of the NPA Act Section 27 or 28 with the investigating directorate, or in terms of the Police Act or whatever. And I differ with you on the slide, because once that person has been included from that forensic auditors or that forensic investigation, they may take part in that if their names are listed in that search warrant. What is your view on that? Thanks.
Then I say to you, I said a search warrant must be strictly interpreted. If it is not in the warrant, then it cannot be done. If what you are telling me is that these names are included in the warrant, then it will be allowed. The same way you see here, I say, the warrant can go as far as to say, we are going to these premises, we are believing that the drugs are under the control of Adam at this location. Now, we are thinking that when we get there may be other persons found at the premises who are also involved in the commission of the same crime. So to cover that, they also get searched because we don't know exactly who they are. The warrant must also say those persons who may be found will also be subjected to a search. So I think your answer is already there, Richard, to say if you've specifically included them in the warrant, they can be allowed. But if they are not in any way included in the warrant, that's why I said if it is not in the warrant, it cannot be done. But if it is in the warrant, you cannot stop it.
Okay, thanks, ma'am.
Thank you so much.
I advocate, ma'am.
No, I'm not an advocate. I'm Elsie.
Oh, ma'am Elsie, sorry.
No, Elsie, feel free.
Okay.
Yeah.
I just want to add on what you say and what the previous speaker said. I used to work for a lot of forensic investigation companies previously. And with regards to searches, our names will also be included in the search warrants. But here is the catch. When we got there and the search, we starting to search the places, we wouldn't even touch anything. It would be the police who would say, maybe take the laptop as it's in this list, and then the other one download whatever that is on the laptop and all that. Because the most important thing is that chain of evidence, because once we go to court, it's going to be the same thing that we actually disputing here, that, but this person, even though his name was in the search warrant, is a member of the public, because after all, we're not peace officers. That's what we try to avoid, to make it streamlined so that when it goes to court, it would be smooth.
Yeah, that's very wise. I agree with that. And also to just be there to preserve how the evidence is collected. It makes sense that the forensic auditors are there because the uplifting, it's also something that, oh my God. Did you guys see the question that just came up?
Yep.
Wow. Guy, I've
The
been
jury
doing
will
this.
disregard that. I'll say the jury will disregard it.
Yeah. Anyway, you know what? I'm worried. My this thing, we're gonna have load shedding, and I might need to change my connection. If I happen to be disconnected, please don't leave if we haven't closed. I'll just reconnect myself. Yeah, just for the record. So yeah, you've answered yourself. Thank you for that input. Do we have anything, Mbali, Mafule? Hey, yo. Yeah. So where do I get all this information that I'm talking about, guys? Really? Hi, Mbali, speak, please. Neutralize the room. I'm on my back right now. I'm defeated.
Sorry. Okay, sorry, Elsie, that was an historic hint. You did answer my
Okay.
question.
Okay, Mafule, Humphrey.
I just want to ask, can the police search the premises when there is no one? Thank you.
They go to somebody's house. What to do? Hey, your question is tricky. What are you saying? They will go into a house and I can say yes. Are you saying with a warrant or without a warrant?
With a warrant.
With a warrant, I
Yes,
would
because
still say with a warrant, I would still say yes. And the answer is I'm gonna base it on the next slide here. Entering of premises should be to arrest, to obtain evidence, and they may do so by using force. And there's this section 27. You see, this section 27 says they can use the non-knock principle where they can break a door and a window, enter. But now the issue there will be if they find something, we can say they planted it, most. Why would they come and do a search when there's no one? Because we can say they planted it.
yes,
You see, we can say whatever you found, if you say it's illegal, fine, it's illegal, yes. But you planted it there because we didn't see you. We were not at home when you came there. So it doesn't make logic. That's why it's tricking me like this. So I wouldn't advise that, according to me. But unless if somebody knows the section, because some people have, but to me, I would just, immediate reaction would be they planted it there. Maybe it's the criminal defense lawyer in me. Okay.
Yeah.
Okay.
Thank you.
Yeah. Okay. So Humphrey was the last one. I see we are still going. I don't know if I'm gonna be off. I wanna come to this one quickly. If we can just deal with the search without a warrant. Section 22 empowers the police to search and seize without a warrant. Ne? In two instances. Mbali, you are stopping us again. We want to talk about searches without the warrant.
No, advocates, I'm not stopping you. I've got another question.
Okay.
Regarding the criminal case. My question is, do I, as a law student or a PLT student, have a right to open a case against somebody which I believe is a victim, or is that going to report my
Repeat your
dignity?
question. Repeat your question.
Okay. Do I, as a law student or a final year student, allowed to open a case against somebody, or is that going to affect me when the years goes by? Like, let's say if I'm doing my bar examination or whatever
Are
exams.
you
Yeah.
saying you are a victim of crime as Mbali, the law student? Somebody has committed a crime against you personally.
Yes. So am I allowed to open a case against that person? Or is
Yes.
that going to affect me?
No. You should open a case against that person. If they assault you, if they rape you, God forbid, if they rob you, you are a victim of crime. Even a judge can do that.
Okay.
Yes, you are a victim of crime. You're going to be going to court to not to represent yourself, but I think maybe that's where you may be getting confused. When you go to court, you will be having the prosecutor as your lawyer. You understand? Yes.
Okay.
So when you are here on this the PLT that you are doing, we are training you guys to be defense lawyers who normally work on opposite to the state prosecutors in a criminal case. So if you are to be in court for your own personal case, you will be coming to court as a state witness. So the one who will represent you, to lead you, to prepare you for consultation for the court, and run you through the whole thing in court is the prosecutor. So yes, you are a complainant in court, despite your title. That's why I said even a judge can become a complainant if they are a victim of a crime. They go and report to the police that they have been victimized. And when they go to court, they are a state witness, and their lawyer is the prosecutor. So whoever has committed the crime against you is the accused, right? And then that accused will get themselves a lawyer who is maybe one of you here, defense lawyers, to go against
Thank you so
the
much, Elsie.
prosecutor. Okay. So don't allow people to victimize you, ne? Don't be shy. The only thing you mustn't do, Mbali, is for you to be the accused. Don't be an accused. Ne? You are not allowed.
All right. Thank you so much, girl.
You're welcome. Okay, so if persons, I was saying the only way the police can do a search without a warrant. Yeah, these laughing faces are very funny. A search and siege without a warrant. Two instances, ladies and gentlemen. If persons consent, they consent. So you submit yourself that go ahead and search me. The police, if they ask you, then they can search you without a warrant. But the second situation is if the police, on reasonable grounds, they believe that this is a criminal or this person has something illegal on them, then they can ask you or subject you to a search without a warrant. That search, okay, now for them to act and go ahead with a search when they don't have a warrant, they have to show that if they first have to go and get a search warrant to be issued, that delay in obtaining that search warrant, it would defeat the object of the search. Mbali, I think you need to lower your hand. So they can say, if we delay to get the search warrant, maybe the person will run away. The person may dispose of the item that we want to find in there, maybe the drugs, they will flush them down the toilet if we first have to go and get a search warrant. So please take note that they are also empowered. If they want to do this search without a warrant, they are also empowered to enter a premises even when they don't have a search warrant. And the only way they can do that is when they have an aim of obtaining evidence. They know that according to their information, there's something they're going to find. So they cannot enter the premises with only the intention of conducting questioning. So they're still looking for information. If they don't have a warrant, they can't enter. No-knock principle, section 27(2) says they can go as far as to break a door and a window to gain entry. Section 27(1) says a police official may use such force as may be reasonably necessary to overcome resistance against the search or the entry. So you can't go and open a case of malicious damage to property that they've broken your door. If they enter and they find something and it actually makes a case, you can't just now come and say they've damaged your property for no good reason. If actually there was something of substance that they found. Now, if the article for which the police are searching, it may be destroyed or disposed of, e.g., it can be swallowed, flushed away in the case of drugs or diamonds, the police need not even audibly demand entry or to announce themselves. Like when they get there, they don't even have to say, open the door, police. They don't have to say that. They can enter unannounced. So you'll just see a door bang, falling and you see people coming into your house. They don't even have to say, this is the police, we are about to break your door. They don't have to do that. You see how far this goes. So please read this case of State versus Gumede. A very nice case, ladies and gentlemen, because it dealt with the whole scenario where the police acted to conduct a search without a warrant. They conducted a search and they seized items that were said to be related to the commission of the robbery. The case is long. I'm not gonna bother you, ladies and gentlemen, but as you can see, it's an SCA case. It's still standing as the authority when it comes to searches without a warrant. So nothing else has come out. So this is the standing authority on, in terms of case law that has bears reference when it comes to what the police can do in terms of searches without a warrant. The police conducted a search without a warrant, obtained evidence as well as a pointing out, which was made a few hours after the arrest. Please go and read this case before tomorrow. You will see how interesting. You may disagree even with the judges when you are reading that case. It's fine, but please just read it. The police claimed that the matter was urgent and that they had no time to obtain a search warrant before the assailant could escape. So it's interesting how the High Court dealt with that case. Up until now, it went to the SCA. Read the reasoning, actually, of the judges in the Supreme Court of Appeal. Very, very interesting to see how they applied their minds to that case. For you to see how, you know, they came to a house, they found an illegal firearm which was taken for ballistics. Turned out that the firearm was unlicensed and also connected to the scene of the crime because someone had been shot with the same firearm. And there was also confessions in that case of Gumede, how the court treated those confessions because they were obtained after the police pounced in the home of Gumede. It happened in the middle of the night. So interesting. Were a police official under unlawful searches, ladies and gentlemen? Someone said you can claim damages against the police when you are in Gumede's situation, I guess. No, okay. According to the police, they received a tip-off in the case of Gumede. LOD, please mute that Gumede and friends were the robbers of an incident that happened about a month prior to them going to the home of Gumede. So, yes, it was a robbery at a pension pay point, you know, where they pay the SASSA money for the elders, for the gogos. Yeah, that's where the robbery happened. So very interesting. So guys, the police official conducts an illegal search and siege. Such evidence cannot be admissible if presented before court. A police official who acts contrary to the authority of a search warrant is liable on conviction to a fine or to imprisonment for a period not exceeding 6 months. Check section 28. You know, we're talking about CPA here. A person who gives false information under oath and a search warrant is issued and executed based on such false information can be charged and convicted of perjury, lying under oath. The court can authorize an award for compensation in terms of section 300 of the CPA to the person who was prejudiced by police who acted out of such wrongful information. Yo, I'm trained. So, yeah, that is searches happening without a warrant, with a warrant, unlawful searches. Any questions? Any comments? I want to close.
No further questions. No further questions.
Thank you so much. Yeah, really, I'm drained. I wanted to take a break. I actually meant to stop at 8 o'clock, but yeah, look at us now. So thank you so much. Let's just pause it here and let's have a good night, everyone. Bye-bye. Night.
Bye.
Bye.
Night, ma'am.
Night.
Sleep tight.
I will. Thank you. Bye.